Welcome to this panel of which is on the question of interpretation and the role that different kinds of commitments to what the constitutional scholars in the room would call method play in outcomes today. We're tremendously fortunate to have three distinguished and truly superb speakers who are each going to give a perspective on this issue. I am not going to recite their bios. I'm going to introduce them and urge you to consult both program materials, but also their web pages at their various institutions to learn about their many, many accomplishments. Our panelists today our conversation today is with Bijal Shah at Boston College Law School, Elizabeth Weiger of the Constitutional Accountability Center, and Victoria North, local to some of you, at the law school on the Hill. What we are going to do is we are going to move along our panel, and each person is going to give you about 10 minutes of remarks on why we either should or should not care about different kinds of claims about methodology. And I think that we're going to hear a little bit of a different set of perspectives about what kinds of methodologies count and what kinds of outcomes can we expect to be associated with different kinds of commitments. After everyone has had about 10 minutes, I'll try and give you each a warning at about the 9 or 10 minute mark. I'll do my best to wave at you. I have one pencil, so one person I can throw this at you. I'll ask perhaps a question of each of you, or maybe two questions, and then depending upon how the room is, how we're doing with questions, we'll bring in audience questions. Two logistical points. First, on your tables, you have pieces of paper upon which you can write questions. So my suggestion would be, as you hear the different speakers, if a question comes to mind, jot it down on a piece of paper, and I believe there are people going to be gathering those paper from the tables as the discussion goes along and bringing it to me, and I can ask those. And so the more questions we have the earlier on, the quicker I'll get to your questions. Second, some of you are getting CLE credit for this. So I am tasked with giving you your two CLE codes, one now and one roughly halfway through. Maybe I'll do it after Victoria has spoken. And the first of those codes is cactus. So it is not hard to be more substantive than a CLE code. But Bijal, I'll turn to you first, and delighted to have your perspective on these questions.
Hi, everyone. Thank you, Aziz, for that introduction. Thanks to ACS for sponsoring this entire event and this panel, and to my co-panelists. I'm really heartened to see such a full room at the end of the day interested in discussing constitutional and interpretive methodology. So thank you in advance for your interest and engagement in this topic, which I do believe has quite a bit of meaning and import for progressive goals. So as of now, scholarship in structural constitutionalism and in administrative law discusses norms in very narrow and limited ways. Generally, scholars view structural constitutional provisions as unburdened by value judgments beyond, say, originalist or indeterminate conceptions of liberty. And while separation of powers theories do aim to constrain governmental overreach, this interest in power rarely engages societal, humane, and equality-focused values. And so the two methodologies of constitutional interpretation that separation of powers scholars rely on are formalism and functionalism, and the center of separation of powers debates is formalism. This formalism as a constitutional methodology relies on formalist ideology, which is the belief that society can resolve disputes according to a neutral system of rules and doctrine. And so, accordingly, constitutional formalism applies originalism and textualism with the view that these are the most objective forms of interpretive analysis. But Scholars like Carrie Franklin and others have revealed that textualism and originalism were in fact insurgent methodologies that took shape as part of a campaign by Reagan-era conservatives to develop antidotes to the judicial activism of the Warren and Burger courts. And so given this backdrop, given this sort of origin story, it's not surprising that in some cases conservatives deploy originalism and textualism as and when it suits them. And so, for instance, in a recent administrative law case called West Virginia versus EPA, the conservative majority of the Supreme Court chose not to use textualism and instead to rely on purposivism to chip away at the Chevron doctrine, which today is associated with a liberal ideology. And in her dissent, Elena Kagan declares that, and I'm quoting her now, "Some years ago I remarked that we're all textualists now. It seems I was wrong. The current court is textualist only when being so suits it. When that method would frustrate broader goals, special canons like the major questions doctrine magically appear as get-out-of-text free cards." So, this is where I'm taking the left turn. I warned my moderator. Now, these critiques are important, and progressives have to both keep fighting these methodologies as well as working within them, originalism and textualism, given that they have taken hold of the Supreme Court. But in my brief remarks today, about 10 minutes, I would like to focus on parsing functionalism. Functionalism is the response to formalism for those who value representative democracy and institutionalism above strict adherence to originalist or textualist principles. A hallmark of functionalist interpretive methodology is purposivism, and it's often favored by progressives who engage with the separation of powers because of its pragmatism. Both its critics and its proponents cast functionalism as results-oriented. But my concern is, does functionalism, which has been embraced by progressives, in fact lead to the ends that progressives want? And so I'd argue simply that we have to take a closer look at this instead of assuming that it does. First and foremost, I'm frustrated by the fact that functionalism among structural constitutionalists and those who research administrative law, including progressives, has become primarily a rejoinder to conservative formalism, a defense of the administrative state. And I think it's important for us to turn our attention inward and to engage the work of deconstructing functionalism, to the work of identifying its theoretical and de facto commitments and determining whether those commitments are in fact being met to the satisfaction of progressive ends. What constitutes functionalism in the separation of powers and administrative law is difficult to pin down today. Part of my goal is to push us to articulate what this means. Right now, I'm working with a sort of working definition that suggests that it consists of a set of democratic ideals that have led to a more flexible approach to the relationship among and division between the branches, and the judicial doctrine that has encoded this approach. Okay, so what is functionalism besides a defense of agencies at this point? Second, even functionalists assume that, unlike the Equal Protection Amendments, the structural provisions of the Constitution do not require a moral philosophy in order to be coherently interpreted or applied. But claiming that the separation of powers is not beholden to any moral outlook does not make it so. Rather, it allows scholars to establish value-laden frameworks of constitutional analysis without acknowledging, let alone questioning, the substance of those values. So put another way, functionalism, progressive functionalism, like formalism, lacks a clear social theory. And so from a critical theoretical perspective, unadulterated support for functionalism is just as unsatisfying as support for formalism. Okay, so perhaps functionalism's greatest benefit at this point is that its emphasis on checks and balances reflects and manages institutional realities. So Peter Strauss, a notorious functionalist and progressive, has characterized functionalists as more attentive to evidence of the concrete social issues catalyzing legislative action than formalists often are. Functionalists also assume that empowering agencies leads to better regulatory outcomes than the anti-agency commitments of formalism. And so many of us are, believe in a robust administrative state. But functionalism in practice may lead to problematic agency actions and bad outcomes. So let me give you 3 frameworks of functionalism and some examples within those that support this statement. One context in which one might critique constitutional functionalist methodology is in the realm of administrative discretion. Now, those who fear a dismantling of the administrative state hold fast to expansive policymaking discretion among agencies. But as Justice Jackson has suggested, nothing opens the door to arbitrary action so effectively as to allow officials to pick and choose only a few to whom they will apply legislation. And so unrestrained administrative discretion has led to outcomes that are problematic for communities based on race, religion. A few examples. In the national security context, Shireen Sinar shows that as an institutional matter, the governmental treatment of international terrorism leads to more severe punishments against racial, ethnic, and religious minorities than the punishment of domestic terrorism. In immigration, another scholar has argued that the discretionary use of arrest records renders immigration enforcement overly punitive. In the area of disaster relief, a scholar has attributed many of the public failures for certain communities after Hurricane Katrina to excessive or inappropriately exercised agency discretion. Now, another aspect of functionalism that I think is ripe for critique concerns the harms and limitations of legislative oversight. In the 80s, there was a case called INS versus Chadha, which deemed unconstitutional and eliminated something called the legislative veto, which was a very direct way for the Congress to be involved in executive and agency action. And supporters of this decision tended to be formalists. Functionalists wanted Congress to have this power over agencies, and today functionalists tend to advocate for strong legislative oversight as well. But this position too has faults. Legislative oversight is a mechanism by which Congress can force agencies to implement private interests or the legislature's own biases. For instance, as Cass Sunstein has suggested, the legislative veto or legislative oversight is a tool for agency capture by powerful interest groups. And in general, sitting Congresses may expect agencies to pursue their own political interests, Congress's own interests, which some scholars have found to be the case as it pertains to congressional oversight committees. So essentially, overseeing Congresses are likely to care about how administrative action impacts minority communities only to the extent that this aligns with the messaging that their majority voters care about. Now, one more aspect of functionalism that I think benefits from a critical perspective is decisional independence in administrative adjudication, really something that many functionalists and progressives have held on to as very important to the functioning of agencies. We argue that independence in the administrative state should be celebrated and preserved by for-cause removal protection for agency heads, by limited constitutional appointments requirements for adjudicators, and that doing so will allow us to maintain expertise and nonpartisanship in administrative policymaking and adjudication. And yet, independence in adjudication, in administrative adjudication, has led to the problematic application of law. For instance, administrative adjudicators may sometimes privilege the government's interests due to a lack of separation of functions within agencies. So I've argued that the fact that the Department of Homeland Security attorney prosecuting an immigration case hails from the same immigration apparatus as the immigration judge can lead to concerning inconsistencies in adjudication processes and outcomes. Alternatively, institutional pressure may arise from the conflation of regulatory priorities across or within agencies. For instance, anti-terrorism concerns and criminal law priorities, overcoming humanitarian immigration priorities in agencies. And then more generally, there is remarkable inconsistency across administrative adjudication. One scholar has argued that this is the case in patent adjudication and that differences exist not because of the merits, but because of the personal characteristics of the examiners. Another scholar has found that Social Security disability is not uniform, and another writes that there is no one who is in a position in the government to promote consistency in immigration adjudication because of the varying temperaments and tastes of immigration judges. So, okay, that's a lot of examples I threw at you. I'm grappling with them myself, but more generally, my takeaway for you is all of this suggests to me that functionalism, despite the fact that it's the sort of set of methodologies in structural constitutionalism that has been held dear by progressives, that it is nonetheless sometimes inadequate for the pursuit of just regulatory outcomes. And so I think we need to question some assumptions that we have held. For instance, our view that a robust administrative state is good. This view must contend with the ways in which the administration of law incorporates value judgments by bureaucrats beyond those that are coded in the legislation itself. We might be suffering from a conflation of our constitutional commitments, for instance, to representative democracy and the social and progressive ideals that we hold. And we're flawed by the assumption that our methodologies are necessarily better for our progressive outcomes or interest in progressive outcomes than formalism. So instead of just fighting conservative formalism, let's also look inward and ask ourselves whether our commitments to formalist methodologies are in fact in service of our values. Okay, thank you for listening. Look forward to the chat.
Elizabeth, can I bring you in here?
Yes,
I think
please.
you have a different perspective.
Yes. So first of all, I just want to thank you all for being in this room for this conversation. Big thanks to ACS for hosting this entire gathering, bringing us all together and giving us such amazing speakers and content. Thank you to Russ and the whole team at ACS. It's really great to be here. And thank you to my fellow panelists. It's really an honor to be on this, to be in this conversation with you. So the prompt for this, the title of our discussion is "We Are Not All Originalists," drawing on that famous quote from Justice Kagan at her confirmation that said, to a certain extent, we are all originalists now. I just want to say, I'm not even sure that the originalists on the court are originalists. It's really more like they're faux originalists. So maybe to the extent that some of us are originalists, it's not the ones that maybe we think are, the ones that might think they are. And to make that point, I want to make two main points. First is that progressives should not run from making arguments rooted in the text and history of the Constitution. And that is because the Constitution, in its most fundamental respects, is progressive. The Constitution, in its most fundamental respects, follows an arc of progress. The story did not end in the 18th century. It did not end with white men in wigs in a sweaty hall in Philadelphia. It was amended over the centuries by generations of activists and abolitionists who fought to make the words of our national charter more inclusive and more equitable, fairer and freer. And because of the work of those generations of activists, we have a national charter that is indeed, in its most fundamental respects, progressive. Now, of course, that is not the dominant originalist narrative. And that's because conservative originalists are telling us a false narrative about the Constitution. This story that the Constitution is all about small government and guns and private property interests is not an accurate statement about the 18th century Constitution, much less the Constitution that we live under today. That is a false narrative. So to the extent that anyone is originalist, which I feel like is such a loaded term, and I really wish that, the work that my colleagues and I do at the Constitutional Accountability Center could be given another term. We tried to call it new textualism instead of progressive originalism. That didn't really catch on. So if anyone has any other ideas, I'd love to hear it. Put it on your card. But to the extent that anyone is really being true to the Constitution's text and history, it's progressives who are making these arguments day in and day out that the 14th Amendment protects meaningful equality, protects genuine justice, that the Constitution protects accountability for the rich and powerful. This is the text and history of the Constitution that is there just as much as the Second Amendment, but conservative originalists won't talk about that part of the Constitution, but that doesn't mean that they're right. And so it's really important, I think, for us to be having this conversation because it's really important for progressives to reclaim a reading of the Constitution that is focused on these progressive promises that are in the Constitution, this progressive potential in the Constitution that has, unfortunately, never truly been made a reality. And if we don't know that history, if we don't know that those words have this meaning, we're not going to make these claims in court. We're not going to root our demands for policy change in the promises that have already been made to us in the Constitution. So it's important, there's power in reclaiming this constitutional narrative. And I think it's important to recognize that, of course, the Constitution has been used as a tool of oppression and not always the tool of liberation that it should be. But drawing on the wisdom of Frederick Douglass, just because the Constitution has been bent toward the purposes of oppression does not mean that it can't and shouldn't be used as a tool for equality and a tool for meaningful justice. And it's important for us to do that. It's really an honor of mine to lead the Constitutional Accountability Center, an organization that was founded precisely in 2008 to push back conservative originalism and say, you know, there's this amazing history and even more coming out every day that shows that the text and history of the Constitution supports progressive outcomes. And I think that having this conversation, and especially with folks who are in law school or maybe at the beginning of their legal careers, is incredibly important for reclaiming that constitutional narrative. It's also practical, in addition to being powerful, to reclaim this narrative. I mean, look, you know, for those of us who are practitioners, like, you have to file a brief. You have to give judges the tools to rule in your favor. And making sure that we have really strong progressive originalist or text and history arguments is incredibly important. And if we don't have these conversations, then progressives are not going to be making those arguments in the best way they can. And it's important to debate. You know, this is obviously a contested space. And so the practical realities of this, I think, are acknowledged perhaps more than even the principled ones, because, look, we do have a court that has a lot of originalists on it. My second point, and I'll close on this, is that it's far more important to show that conservatives are wrong about the Constitution than to bury the originalist brand. And I say that for a couple reasons. It's important to say that they're wrong and not just that they're originalist, and that's a bad word, and so they must be bad. It's important to show that they're wrong in what they say about the Constitution because they are. They are wrong about it. And they're not wrong about it because they've chosen the wrong judicial method. They're wrong about it because what they're saying about the words of the Constitution and what outcomes they require, it's wrong. And you can do all the historical work. I highly recommend that you do. It's really, especially the history around the Reconstruction Amendments and the 14th Amendment are incredibly inspiring and frankly far more radical than the 14th Amendment has ever been interpreted by the courts. They're wrong. And arguing that originalism as a method is just something that we need to get away from because the method is bad presupposes that the method gets you to the results. And if the method is anything like it's supposed to be, which is, you know, you look at the words of the Constitution, you look at the public meaning surrounding them, then you're giving conservative originalism far too much power than it deserves. Because it's not that they got the method of interpretation wrong, it's that they're getting what they're doing in it wrong. And I will leave for another conversation, because I'm a litigator, whether they're doing it intentionally or not. I'll leave that for other people to talk about. But the point is that they're wrong. And finally, the reason why I think it's more important to show that they are wrong about the meaning of the Constitution than to just trash the brand of originalism is because neither judges nor real people really care about the methodological jargon that we put on this. They care about what your understanding of the Constitution means for their real lives. That's what real people care about. They care about what this means for their lived experience of constitutional rights and whether they have them or not in a real and genuine way. They don't care whether it's purposivist or originalist. They want to know what you think about the Constitution and how it affects them. And frankly, judges are not as worked up about this as I think a lot of times we are. And I will close on the note that I had hope when I listened. Well, I'd hope for many reasons, listening to the amazing confirmation hearing of Justice Ketanji Brown Jackson, but I love that she refused to be pigeonholed. She said, look, this is how constitutional interpretation works. You look at the provision before you, you think about what those words mean and why they're there, you look at the facts, and you go from there. So I think rather than being so obsessed with whether it's originalist or not, we should be looking at what is the constitutional argument. Is it right? Is it not? Is it a misrepresentation of the words that people fought so hard to get into our Constitution? And does it lead where it should, regardless of ideological agenda? And the answer far too often in this court is no. But we can make it yes if we work hard enough. And I look forward to having more of this conversation. Thank you so much.
Thank you so much, Elizabeth. And if I can turn to Victoria for our last presentation, and then we'll have some questions. And again, I encourage you to write down questions as you listen to our wonderful panelists, and then I'll bring those in. Sorry for interrupting your beginning.
No, thank you, Aziz, and thank you. It's so delightful to be among these women. I only had one woman law professor. And so it's, at my age, just an incredible honor to sit here with these amazing women. And I want to thank Russ and ACS for doing a fabulous and last-minute conference. I've been running in and out because I've been working on the ERA. I've been in 6 different cities raising money. So forgive me if I use my computer for some notes, because this is a pretty fancy audience, and I want to be clear. I also have a slightly different perspective. I'm real local. I've worked up and down Pennsylvania Avenue, and I work at Georgetown. So I always have slightly different views than some law professors, and this speech is more in a register of a speech than an academic conference, because I think now is the time to make this speech. If you aspire, you care about the rule of law, cannot look at what we have experienced, and as I did at my home on Capitol Hill when the insurrection walked past. Unfortunately, the title of my talk is Originalism as Violence, because that is what it has come to do in the world. Whatever it means in academia, Randy Barnett doesn't like Dobbs, forget that. But what have we seen in the world? Judicial ideas don't exist in a vacuum. They are at conferences like the Federalist Society or ACS, and they get inside the White House counsel's office, and they get inside chat rooms. And the problem is that originalism is now a political theory. It was a political theory in the 1980s when it was created, and it is now a political theory as well as a legal theory. And the political theory has indeed given us violence. The public justification for the former occupant of the presidency, Donald Trump, was that he had all executive power, and he said it over and over again. And where did he get these words? From a dissent, Morrison versus Olson, in which Justice Scalia wrote that the president has not some executive power, but all executive power. Now, what does the text of the Constitution say? As my friend Wydra says, they're not true to the text. It doesn't say all power. The court has never defined executive power, as my friend Shaw understands, Professor Shaw. So we have the president saying, I have all executive power. And he goes out and he finally refuses, based in this thing, I've got something called Article 2. He learned that from his White House counsel. All right? And what do we get? We get an insurrection. And what was the theory that justified the insurrection? John Eastman. John Eastman said, I don't have to look at the statute. There's a complicated statute. I work for a vice president. I know how to count the electoral things. It's really boring usually over there. But he disregarded the statute, and he said the Constitution governs, and I'm going to look at one part of this and say 7 words means that the vice president has all power to determine an election. Now, that was when some of the White House counsel said that's group crazy, right? But he's still out there claiming that he's an originalist, and he's all out there saying that he has the power to look at these words. Now, we all know that they are inserting and subtracting what they like, and we need to make better arguments on that front, but that's what is going on. So you say, well, why? You're being too aggressive, Victoria. This isn't, that was just some crazy people out there. That's not the Roberts Court. But shouldn't we have known? The insurrection really, it did walk by my house. And so I moved. It really had an effect on my life. And I kept thinking to myself, what if someone had actually paid attention to the fact that Justice Scalia really lopped off part of the Second Amendment? We knew this started in violence. Their great claim to fame is the right to bear arms, which never existed during my long lifetime before then. And now, what do we have? Dobbs. And this is why we are at a different time now than we were even 2 years ago. Originalism has become politically salient, as a political scientist would say. It has come to people's houses, their decisions about whether to have children, where to live, what will happen if they have a miscarriage. I knew this would happen when I saw Saturday Night lampooning Dobbs for going back to the 13th century. All right? Because anyone who studies the Constitution, and I know Professor Hook knows this, there are constitutional cycles. And there are cycles because we have a hydraulic process. The hydraulic process comes from elections. The real reason for the Constitution is not courts. We teach that all the time in law school, but it's not. It's elections. Take away the courts, you still have a democracy. Take away the elections, you don't. So that's what we should be teaching more of, because it creates the hydraulic force. And history tells us that after Dred Scott and after Lochner, majorities who are barred from getting their aims done through Congress or state legislatures will fight back. And typically they win over time. So I have gotten to say, I'm one of those people who, I'm not trying to trash originalism. No one knows actually what that means. As I said, academic originalists don't think what the court is doing now is originalism necessarily. And I don't want to get into that academic debate. But what the political theory is now, and that political theory, in my view, is anti-democratic, anti-woman, anti-minority, and anti-American. And I'm willing to say that out loud. I just said it in Palo Alto, and we got a standing ovation. This is no longer about the courts alone. We cannot go back to 1868. Yeah, there's a lot of great history, but guess what? Women were never included in the 14th Amendment, and Justice Scalia has said it over and over again. That's where we are. I understand the practicalities of litigating. I love doing history. My first articles were about the Federalist Papers. We got to keep doing that. I completely agree. But the other side has played for the rules. And I grew up working in the body called the Senate. And there are folks, I know that Russ Feingold knows this, who say, look, if there's a choice between the rules and the substance, I'll always pick the rules, and I'll always win. We have not played for the rules. I don't want to trash originalism as an academic theory or anything, but I do want to say that going back to 1868 is not acceptable. What happened in 1868? We were coming out of a civil war, disease, poverty, women. Most of the people in this room couldn't even read. We're not going back there, and the public knows it, so the constitutional conversation is changed. I have spent 15 years on the inside trying to show you why the rules are just what, my friend Wider has said. They're manipulated. They're full of contradiction, and I hope you will show them the contradictions. Why look at the Federalist Papers if you won't look at the legislative history of 1964 Civil Rights Act? It will take work, but I do think we have the tools. We have to be better textualists than they are, show them how they're adding and subtracting from the text. We have to explore the contradictions. There was no sexual orientation in 1868. And we have to understand that we are at a different moment in time, that there is a political theory of originalism and there is a legal theory of originalism, and they may be different. Finally, I think that one of the biggest problems here, and this goes back to Professor Shaw's comments on the separation of powers, is that we don't understand the proper constitutional ontology, which is to say what the Constitution is. It is a frame of government that creates elections, creates democracy first, and the Supreme Court, and just one court, as an afterthought, if you read the Constitutional Convention. The court is not above the people as they now believe. They are its servants. And we've been teaching them in constitutional law for too long. We start with Marbury. The court is supreme because we say what the law is. Trust me, if I go to the president's office, he says what the law is too through executive orders, and so does Congress. Originalism has been deeply inconsistent with the theory that the text is sacrosanct because it responds to ordinary citizens. That's the latest bit on statutory interpretation. Oh, we're just ordinary people. We are populists. Justice Barrett calls me a congressional insider. Ordinary people do not read the Constitution by returning to what was the law in 1868. Justice Scalia railed against a system where the laws were on a pillar. You could not see them, and that is what this has become. It has bitten itself in the you-know-where. So I'll end with that. I'm so happy to be here. ACS has collected people who care about these issues. We'll continue to have this debate. And I understand all the many things that have been said here before. We need to be in on all of these items at once, because it is both a political and a legal fight. Thank you.
Thank you so much to all three of you. I encourage people again to write down their questions and to, I assume somebody will bring them up here and I will start asking them. I am also told, and this may naturally flow from what Victoria said, that I need to give you the second CLE code, which is hemlock, which I think is an appropriate word for your talk. Okay, so while I wait, I've got some. Well, I'm gonna take a second to ask each of you one question, and in that time, I will have time to read these and turn them into questions myself. But what I'd like to do is to ask perhaps one question of each of you in turn, and maybe we'll bring in the questions from there if that's okay. So, Bijal, maybe I can start with you, and we'll just go down. I want to ask a question about the court and about the outcomes that it reaches in the separation of powers today, and whether the distinction that you drew, and that's common to the literature between formalism and functionalism, tells us anything about what the court is doing. So the premise of what you said was that, well, the court's functionalist. The court is formalist. We need to develop functionalist arguments against it, right? But then we need to be critical of the places that functionalism will lead. But is the court really formalist? If you take, for example, the removal clause jurisprudence, the cases invalidating various kinds of agency structures because the president has insufficient control, a central line of argument in those cases is functionalist. Mm-hmm. It's that the president doesn't have enough control. Mm-hmm. A central line of criticism in the Chevron or non-delegation cases, the major questions doctrine, is precisely functionalist, that a system of agency, deliberation, and decision-making over a certain set of policy questions is not adequately democratic. So are we getting it right up front in characterizing the Roberts Court in the areas that you work on as being formalist in the first place? And if it's not formalist, well, isn't that a ground for criticizing functionalism?
It's a great question, and it brings in a lot of, I think, important and interesting doctrine that bears on the sort of topic of whether the court is functionalist or formalist and to what purpose. And so both I and Professor Norse spoke a bit to how originalism and methodologies in general are used in order to reach certain outcomes, right? And in particular, in the formalist space, this is the case. And so the major questions doctrine that you asked about, the most recent decision was the West Virginia case that I mentioned briefly, in which the court, in fact, took a purposivist route in order to carve out a sort of functionalist way for basically the courts to wrest control over administrative policymaking. The other piece of this, as you mentioned, is the removals test, which is basically whether or not the structures of independence that Congress has put into place in the administrative state interfere with the president's ability to take care that the laws are faithfully executed. A very, Scalia hated it, a very sort of a functionalist approach, right? And so I think something we can take from this sort of going back and forth that the court has had between taking a more formalist approach, for instance, in the CFPB case, and as it pertains to appointments, and then a more functionalist approach to applying the test and the removals, and in kind of matters of administrative law and Chevron, is that they are seeking certain outcomes, right? This is precisely what Kagan pointed to in her dissent, and she couldn't have said it more bluntly than she did, in her statement about we're not textualists now. We are only textualists when we, the court, are benefited by textualism in order to get to certain outcomes. And today, textualism didn't benefit you, and so you chose purposivism in order to, further limit the administrative state. And so, I think. Yeah, so the final question, the kind of capstone of your question is this a critique of functionalism? I think so. I mean, I think what I'm trying to do is encourage all of us to make more critiques of functionalism in order to ensure that it operates better for our purposes, right? And so to the extent we can identify instances where a conservative court is drawing on functionalism in order to come out with conservative outcomes, this is an important spotlight on the weaknesses of functionalism that we should be paying attention to. And so I honestly couldn't agree more. I wish I had a dissenting opinion, but I don't. Thank you for the question.
Great. Let me turn to Elizabeth, and I'm not going to ask my question. I'm going to ask, I have two questions for you, one for Bijal. I'm going to ask you the two questions in combination, and if there are not more questions, I can ask my question later. Let me do the audience questions. Here are the two questions. First, for 5 points, name an originalist argument that the court got wrong. I think that's not even worth 5 points.
Oh my gosh.
But here's, I think, maybe a harder question. 10 points, which is, how can you be in favor of the progressive constitution after Dobbs and the shadow that Dobbs casts upon substantive due process rights? I presume this means substantive due process rights as recognized in Griswold, in Eisenstadt, maybe in Skinner, but not, I take it, Lochner or the like. I think that's the premise of the question.
Thank you so much, and thank you to the two folks who submitted those questions, especially because they go hand in hand. Dobbs is like the most unoriginalist argument if you're actually taking the text and history of the Constitution seriously. I will talk about it briefly, but if you want to know even more, I highly recommend my colleague David Gans's article, Reproductive Originalism, on this, which is brilliant. And I'm not just saying that because he's sitting here. So Dobbs got it totally wrong. I mean, first of all, if you look at what the words equal protection mean in the 14th Amendment, if you think about what liberty means in the 14th Amendment, and you look behind why those words are in it, particularly the testimony that was collected by the Joint Committee on Reconstruction, you can see that they wanted to provide an irreducible minimum of freedom after the horrors of chattel slavery, including, perhaps most brutally, the violent infringements on a person's bodily autonomy in terms of determining for themselves, of course, with respect to reproductive autonomy. And so the 14th Amendment, part of that irreducible minimum in those words equal, in the word liberty, includes the right to decide for oneself whether, with whom, and when to form a family. And the court recognized this in some way in the Meyer versus Nebraska case, in sort of the modern due process jurisprudence, but it's very viscerally, powerfully there if you look at the text and history of the 14th Amendment. I don't think we've ever had a Supreme Court decision that has recognized that is inherent in the 14th Amendment to the radical extent that it is there if you look at the history surrounding. And so when Dobbs ignored all of that and instead went back to the 13th century, I guess, when the actual history doesn't work for you, you just keep going back till you find some that's sufficiently regressive. But not only did they ignore that, but they also, when they did the original public meaning part of the originalism methodology, they looked at the discriminatory, regressive laws that were on the books without taking into account that the 14th Amendment was specifically intended to be a constitutional disruptor. It was specifically intended to disrupt state practices that had been oppressive, that had fostered subordination. And so to use what was supposed to be a constitutional disruptor to place into constitutional amber discriminatory practices turns the amendment and what it was supposed to do on its head. So that's how I can still fight for and support the progressive Constitution, because Dobbs does not reflect the actual Constitution. It reflects Sam Alito's Constitution, and Sam Alito's and the other justices who signed on to his opinion, his vision of what equality and liberty and freedom is protected in the Constitution. But that's not what's actually in there. And just because he said it doesn't mean it's true. So thank you for those questions.
Thank you very much. I'm happy to take more questions. Let me turn to Victoria. And I don't have a question for you, so I'm going to ask you one of mine, if that's okay.
Yeah.
You drew a distinction between, on the one hand, originalism in the political domain and originalism as an academic or a judicial practice. And I want to ask a question about the first, about originalism as a form of popular politics, as a form of violence. And the question is this. I'm very sympathetic to the reading that you give of what happened on January 6th. And one might point, for example, to the particular kinds of imagery that people used, such as the Gadsden flag, which is an image that dates back to the founding era and that represents a certain kind of, or has come to represent a certain kind of claim to white supremacy. So there's clearly an important strand of popular discourse. We see this, for example, in the constitutional sheriff movement out west. It's clearly a kind of popular discourse that employs originalism as a justification for hierarchy and the deployment of violence for hierarchy. But the question that I have, and it is a genuine question, is there anything distinctive about originalism in that regard? So I worked for a bit in Sri Lanka. And in Sri Lanka, there is a tremendous amount, right? There's lots of different kinds of violence at the time that I was there. And I was working as a political analyst. But one of the most important forms of violence was violence committed under the aegises, under the auspices of Buddhist monks against the Tamil and the Muslim minorities. And Buddhist scriptures, so far as I am familiar with them, are not terribly hospitable to claims of violence against others. And yet, that ideology can be turned. It can be put on a flag. It doesn't have the beehive. It has a different kind of image on it, and it can be used for violence. The same thing can be said of liberalism. The same thing can be said of socialism. The same thing can be said of libertarianism, I think, in a pinch. Any ideology can be put on a flag, and that flag can be hoisted at the head of a group of mostly men, mostly with guns. Is originalism any different?
Well, I agree with that. I think that the political event should inform people who are actually consider themselves, whether they're liberal or conservative originalist, to think about the feedback. Okay, so I'm going to turn the question around, Aziz. It's a very important question, and one that anyone who is a committed originalist would ask me. Well, what does that have to do with anything with the law? And I think that the people who are advocates of originalism in the court sense, and I am distinguishing that from what might be done at the Constitutional Accountability Center, and as I said, Randy Barnett, my colleague, who is like the originator of original public meaning originalism, would say, the court's originalism, right, has unfortunate political leanings connected to that political ideology. And so I think people who are officers of the law, Aziz, you're absolutely right about the political piece. Anything can be doing that, you know? But people who are officers of the court need to ask themselves whether it's not the method in the court, but they have priors, and all those priors, right, have been wrapped up into this, and that they have become infected by that political bias. So I don't want anyone to be neutral. I want people to go after the bias, right, and see it's ultimately, I am a, con law nerd. I want them to think again about what they have wrought in the world. The people who are the lawyers. Does that make sense? Because I value the rule of law.
Let me ask, I have one more question from the audience. Thank you very much, Victoria. I have one more question for Bijal, and then I want to take the last two questions, wrap them up into one, and actually ask all three of you as a way of rounding off. So here's the question for you, and I'm going to paraphrase a little bit. You can't beat something with nothing. If you don't like formalism and you don't like functionalism, the question asks, would you have a progressive common good constitutionalism? But whether you want to take that on, I think that's a separate, maybe that's a separate question. But maybe you can't beat something with nothing. What would you beat it with?
No, the sort of next question in response to my remarks would be, so does this mean the answer is in fact to dismantle the administrative state, right? Have the formalists been right all along? The administrative state does these bad things in conjunction with other kind of political, the other political branch, excuse me. And so really the formalists were right all along. That is the sort of quick response to my statement. And I don't think that the answer is to swing in the exact, swing the pendulum to the other side of the spectrum and to go sort of whole hog with the blunt response that formalists have. I think there is room, for instance, to bring in legal realism, bring in critical theory, critical legal studies, critical race theory, to sort of think about how we might adjust both the values that we, this is a different space than I often speak in, right? So I can be pretty clear about my progressive interests and that I care somewhat about the ends, right? But to the extent that that's what we're talking about advocacy and movement, as opposed to sort of displaying the supposed neutrality of an interpretive methodology. I think there are ways for us to think critically about how to shape and change functionalism to better accomplish what we're trying to accomplish, instead of simply using functionalism as a defense. And I think that's the piece of it that frustrates me the most, that it's been watered down to, Gillian Metzger saying no to the anti-administrativists, and none of us really doing much except standing in line behind her because we don't feel like we have the freedom to take a moment to actually look inward and figure out how to shore up our own methodology in the face of this constant attack. So no, it's not that I would throw the baby out with the bathwater. I want to think about it a little more and consider whether our blind allegiance is as it should be. So.
Great. So we have about 10 minutes, and I have two final questions, which I want to, again, combine into one. And maybe we can go in reverse order and answer them. And the first question, let me tell you the two questions, and then I'll combine them. The first question is, are there interpretation-specific reforms that you would propose? And the reform that's suggested is mandate that the court consider legislative history, which might be done through an actual provision of a statute that says, if you want to know what this means, look at X and Y legislative reports or the like. So the first question is there a interpretation-specific change that you would make to the world? The second is the much larger question of if you could reform the court, what would you do? And I think maybe the way to combine those two questions is pick a path, big reform, little reform, have it be about the courts, and tell us why you think if you could, you had the Harry Potter wand and could wave it and make it happen immediately, which reform would you pick and why? Big or little? And what would it be? Sorry, that's a very big question.
No, I've been working on that. Not that I have any magic wand. So thank you for asking the question, and it's an excellent one, because it is the time to begin anew, as Hannah Arendt said, and to think anew. So there was a judges' conference here, and I gave them a 5-pager, and this is for statutes. It also applies to the Constitution, but for statutes, I think we should use the rules of evidence to actually include all evidence. And that includes I call it legislative evidence, not history. People should not be doing history because they should be looking at the text. But there are ways in which this court has been very hostile to a lot of their doctrines we've been talking about. They're just hostile to Congress. They don't like Congress. Their only experience of Congress is their confirmation hearings, and that's pretty nasty. And they think members of Congress are stupid, and they're biased against it. Congress can push back. I'm working with some people on the new Rule of Law Committee, Farber, Eskridge, Bertrand Ross, trying to get them to do things in the intermediate term that cannot be done by packing the court or all the grand things that were suggested in the Supreme Court Commission, which are fine to discuss, but they're not likely to happen anytime soon. So there are intermediate things that are in, this sort of, let's learn to really be good textualists. They add and subtract all the time. 4,000 words will never give you the answer to these questions. It just won't. The interpreter will have to add meaning or subtract meaning. And it's very obvious. You give people two examples. One, all executive power, we've heard that, and the other one is Heller, take out the preamble. But I do think that the best way to go right now in terms of reform is sort of an intermediate solution. I'm an expert in this. I don't want to bore people with all the details of this evidence-based theory, but I think it can be done, and I think Congress has to step up. Whether they'll want to, that's another question, but it doesn't hurt that people are worried about dark money and corruption. So what would I do if I had a magic wand? I would do all those things, but I'd also get rid of their certiorari jurisdiction, because they get to decide the cases they decide. And I'd get the Court of Appeals to decide which cases they decide.
Elizabeth?
Yeah, well, thank you. That was super interesting. I love having this thought experiment, and I particularly love it because I would never quibble with Victoria's surely just assessment of the situation that nothing is happening anytime soon, but I think that means that we therefore should think big and bold about what our reforms should be, because we need to work toward this actually being able to happen, and don't start with your lowest negotiating position. Let's think big and bold about this. And because we do like to look at history, we look back to a period, Reconstruction, when pretty much everything we're talking about now with respect to court reform was on the table back then. They were talking about jurisdiction stripping. They did actually expand the court. They talked about changing whether the court can decide certain issues. A lot of the same things that we're talking about now. And while certainly adding justices to the court did have a big impact on a few cases, what we actually saw was the most impactful was congressional legislation enforcing constitutional rights. So, for example, Section 1983, which provided a new mechanism for accountability. Now, of course, Section 1983 is currently being hollowed out by the judiciary, so maybe we need 1983 Part 2. We really meant it the first time. But I think that's what I would do, would be to think about what are these reforms that get at the much larger problems of justice that are on the table right now. It's not going to be solved simply by adding a couple more justices or a lot of more justices, depending on your view. Although I do think that that's a good start, just even for basic good government reasons, to add more justices to the court, and certainly to add them to the lower courts. So yes, 3 cheers for that. So we also have to think more broadly about what are the problems of justice we're seeking to solve. And those, I think, need broader legislation focused on how to manifest meaningful justice.
Peter, you get our last word.
Well, my goodness, what a terrific set of questions. What wonderful engagement from this audience. Thank you so much for your attention to our conversation. So the question is twofold. One, what adjustments would I make to interpretive methodology? And two, if I could wave a magic wand, and it is magic, and shift the court in some way, what would I do? So I'll answer simply. When it comes to methodology, I would urge my progressive siblings in arms that are engaging with originalism to not only contend with how originalism as it's currently sort of practiced can lead to progressive ends, but also to sort of grapple with the context of originalism, the voices that were excluded at the time, whose perspectives did not make it into the conversation and into the sort of background information that leads to the support of originalist methodology, the sort of idiosyncrasies of originalist methodology that often convey sort of conservative biases or conservative predispositions instead of taking into account a more progressive understanding of context at the time. So in terms of the study of methodology, that's something I'm hoping to see more of in the literature and maybe even among those who litigate. In terms of waving a magic wand with the court, I don't know how to translate this suggestion into a mechanical change, but I still remember Justice Sotomayor's honest sort of expression of who she was and what she brought to the table when she became a justice, right? That her lived experience was part and parcel of how she made decisions, and it couldn't be any other way. And if I could wave a magic wand, it would be to somehow force all of the justices to come forth with their lived experience and to grapple with how that experience and how their priors in fact shape their decision-making in an honest and explicit way. Because just because the justices are not leading with this does not mean they are not engaging in this way. And it's, I think, important for them to understand and for the public to understand better who they are and their beliefs, in fact, play into their decision making. And so I don't know what that would look like as a matter of process, but I'd love to see that happen in some sort of real way, if possible.
I think Elizabeth is going to have a last word.
Oh, sorry, I didn't mean to have a last word, but you made me think of Brandon Hasbrook, who was going to be on our panel. I wanted to invoke one of his fantastic articles, he has several, on this point about the voices that we consider when we engage in constitutional interpretation. He has this wonderful article, The Anti-Racist Constitution, which I highly recommend, that talks about exactly that. The lens with which you view original public meaning is incredibly important. And I think a lot of times we aren't challenging the narrow lens that's being used by conservative originalists, because there are a lot of other voices. There are indigenous voices, there are black and brown voices, there are voices of women, there are people who might have been excluded from the process in certain ways, but had a lot of thoughts about what the Constitution meant in that moment, and especially when we're talking about the Reconstruction amendments, but also I think really importantly, women's suffrage amendment. A lot of these amendments, there are these broader voices that have not been told through the history, partly because of structural racism, frankly, in the academy and historians and how that history gets told, and then also who is on the bench and who is engaging in this original public meaning analysis. So on behalf of Professor Hasbrook, I wanted to applaud that point that you made and encourage you to read the work that he's done on this, lifting up these voices, because it's incredibly important doctrinally, and I think also culturally when we think about ourselves in the story of We the People.
Thank you so much. I wanted to just briefly reflect a theme that comes out of all of your remarks, which is one of responsibility and the idea that, as Bijal said, one needs to have responsibility for the choices that one makes, whether it's a judge or a citizen, and think about what their consequences are. What Elizabeth has said about the way in which judges who profess themselves to be originalists do not follow that label to its end, and the way that, as Victoria explained, those judges will invoke a kind of rhetoric that has spillover effects in the public domain that are quite terrible to behold. And maybe one theme that emerges out of all of these remarks is a critique of originalism, not as a distinctive methodology, but as an ethical move, as a way of saying, it's not me, I didn't do it, it's not something that I have to take responsibility for.
Yes.
And whatever the disagreements, I think that were really productively generated by our wonderful panelists. I think that their joint insistence on the idea that we must take responsibility as judges, lawyers, and citizens for our Constitution and the way that we implement it today, it's a more timely message can't be imagined. Thank you so much to all of you.
Thank you.
Thank you.